3, 2, 1, start. Where a winding up order has been made or where a provisional liquidator has been appointed, the liquidator or the provisional liquidator, as the case may be, shall take into his custody or under his control all the property, effects and actionable claims to which the company is or appears to be entitled. Stop. For the purpose of enabling the liquidator or the provisional liquidator, as the case may be, to take into his custody or under his control any property, effects or actionable claims to which the company is or appears to be entitled, the liquidator or the provisional liquidator, as the case may be writing request the chief presidency magistrate or the district magistrate within whose jurisdiction such property, effects or actionable claims or any books of account or other documents of the company may be found, to take possession thereof, and the chief presidency magistrate or the district magistrate may thereupon, after such notice as he may think fit to give to any party, take possession of such property, effects, actionable claims, books of account or other documents, and deliver possession thereof to the liquidator or the provisional liquidator. Stop para. For the purpose of securing compliance with the provisions of subsection, the chief presidency magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may in his opinion be necessary. Stop. Section Act that the tribunal may at any time after making a winding up order require any contributory for the time being on the list of contributories, and any trustee, receiver, banker, agent, officer or other employee of the company to pay, deliver, surrender or transfer forthwith or within such time as the tribunal directs to the liquidator any money, property or books and papers in his custody or under his control to which the company is prima facie entitled, all debts payable on a contingency and all claims against the company, present or future, certain or contingent, ascertained or sounding only in damages, shall be admissible to prove against the company, a just estimate being made so far as possible of the value of such debts or claims as may be subject to any contingency or may sound only in damages or for some other reason may not bear a value. Stop para. In the winding up of an insolvent company, the same rules shall prevail and be observed with regard to within bracket A debts provable within bracket B the valuation of annuities and future and contingent liabilities, and within bracket C the respective rights of secured and unsecured creditors as are in force for the time being under the law of insolvency with respect to the estates of persons adjudged insolvent, provided that the security of every secured creditor shall be deemed to be subject to a pari passu charge in favor of the workman to the extent of the workman's portion therein, and where a secured creditor, instead of relinquishing his security and proving his debt, opts to realize his security within bracket A, the liquidator shall be entitled to represent the workman and enforce such charge within bracket B. Any amount realized by the liquidator by way of enforcement of such charge shall be applied ratably for the discharge of workman's dues, and within bracket C, so much of the debt due to such secured creditor as could not be realized by him by virtue of the foregoing provisions of this proviso, or the amount of the workman's portion in his security, whichever is less, shall rank pari passu with the workman's dues for the purposes of section 529A. Stop. All persons who in any such case would be entitled to prove for and receive dividends out of the assets of the company may come in under the winding up and make such claims against the company as they respectively are entitled to make by virtue of this section. Stop para. Provided that if a secured creditor, instead of relinquishing his security and proving for his debt proceeds to realize his security, he shall be liable to pay his portion of the expenses incurred by the liquidator for the preservation of the security before its realization by the secured creditor. Stop. For the purposes of this proviso, the portion of expenses incurred by the liquidator for the preservation of a security which the secured creditor shall be liable to pay shall be the whole of the expenses less an amount which bears to such expenses the same proportion as the workman's portion in relation to the security bears to the value of the security. Stop. For the purposes of this section, section 529A and section 530 mean within bracket A, workmen in relation to a company means the employees of the company being workmen within the meaning of the Industrial Disputes Act 1947 within bracket B. Workmen's dues in relation to a company means the aggregate of the sums due from the company to its workmen as per the law. Stop.